All right, welcome back. We are going to take some time right now to have a bill introduction for H-184, which is, yes, please join us, Representative Otis. Thank you for making time out of
my busy schedule.
Yes. Ways and means, so we actually shouldn't be seeing you until December at some point. But the H-184 is an act relating to exempting an owner of rental housing from renovation, repair, painting, maintenance licensing requirements. Do you know everybody here?
Yes, I do, and it's Carol Odie for the record.
All right, so if you know
Burlington.
we won't go around the circle. We'll
no,
just
you don't.
Say, pass the microphone on to you. Thank you. You're welcome.
Thank you, Chair Stevens. In 2018, the legislature passed a law that asked the Department of Health to further regulate lead paint. And when regulating lead paint, there are 3 groups to know about and 2 buckets to put those groups of people in. The first group are professional contractors and remodelers. The second group are landlords. And the third group is childcare. So those 3 things are put into 2 buckets. The first bucket is licensure with fees and mandatory insurance required of them to be painting, according to lead law. And professional contractors and remodelers, that's one group, are in that bucket. And in the other bucket are landlords and childcare. And they are certified. They all have the same training, but there are no fees or mandatory insurance required of the landlords and the childcare providers. The Department of Health said that they would put landlords in with childcare in bucket number 2, which is to be certified, but not to pay fees or mandatory insurance. And instead, the Department of Health put landlords in with professional contractors and remodelers. And this bill would put those landlords back in the same bucket as childcare, so that they would have the same training, but no fees or mandatory insurance. That's it.
No, thank you. If I started quizzing you on the history of lead paint laws, would you?
Would I know this? Probably not. Probably not. But I do know that, if you're a landlord and you own housing that's built before 1978, you do have to get EMP training, and landlords do have to do that, and they do that, and then they can supervise a painter who's doing the work or do the work themselves. But this goes beyond that requirement and asks landlords to get the same, have to have no different of education, but they'd be required to have licensure fees and mandatory insurance. And you'll find out in testimony tomorrow why that's not tenable for landlords.
Okay.
For example, they can't even buy the insurance. They wouldn't be allowed to buy that insurance because they're not a professional. But there'll be more tomorrow on that.
Sure. Representative Elder.
So this lets them operate under a certificate instead of a license, really is what's in the language I'm seeing.
Yes.
Or that's the intent. I don't know. But would you characterize this as like a mistake that that they got put in with the property? Like,
yes, I would, because if you can't even comply with the law, with this law if you're a landlord.
Right. I'm just kind of interested. It kind of seems like, and some people who have spoken to about it seem to be thinking that really to put the landlords in with the professionals, which would require licensure, which they're not able to do, is not the intent. And if that's the case, then certainly it seems like a good fix to do. My other question is, I have noticed that this issue is of particular importance to Burlington. And I is obviously statewide law. I just wonder why we're hearing about it more from Burlington. Maybe it's because Burlington is applying this in a way that other municipalities without their kind of zoning and regulatory regimen or not. I'm not sure. I'm just kind of interested that this is a piece of statute that we're really seems like it's affecting Burlington a little uniquely and
I'd have to say, I
is
don't
being
know
brought forward by
about,
3 Burlington reps.
yeah, well, that's probably because we have an attorney who is a former legislator who noticed this and wants to rectify it for all landlords. And I've received actually some letters from landlords outside of Burlington.
Okay. Yeah. So maybe it's.
Received a lot from people in my district.
I have
That's,
too.
oh, that's great. Yeah. I haven't, the people who've reached out to me have all been from Burlington. So I was just kind of,
Oh.
including some people who I know personally who, you know, and so that may be why, but, no, just curious, really not a problem, even if it was, but it sounds like it's not. Well, anyway, it, especially if it was not our intent. Yeah, I believe that legislation has to be revisited sometimes after the fact to patch up where the rubber has inadvertently hit the road. So, you know, maybe this is an example of that.
Representative Burrows, Krasno.
That was it.
Representative Krasno, that's just not tangible.
Thanks, Representative Odie. I am very supportive of this and in a time when we are in a housing crisis and you know, we're concerned that fees will have a ripple impact. Can you state for us all what the cost would be again for landlords if they were to have to
Well, as I understand it, but you can get testimony other than from my understanding, you would have to be a professional contractor or remodeler or something professional to be able to obtain the actual insurance that's required in the law. And a landlord could be anybody. Isn't a professional licensed contractor of any kind
right?
necessarily.
And do you know, and maybe others do in their testimony, what penalties or oversight there would be if folks didn't follow that direction?
That's a good question,
Okay.
and I don't know the answer. I imagine there would be legal liability, if nothing else.
Thank you so much.
Thank you.
So thank you, Representative Bodie. Just trying to understand the background of this more. My understanding is that this came about through rulemaking, is that right?
Yes,
Okay. And I know that rulemaking is its own process
that's right.
and something like this can make perfect sense step by step if you're looking at lead paint, when it comes through the rulemaking process and seems to make sense, and then you discover the unintended consequences. So I was just trying to understand if that was the process.
Yes,
Through rulemaking.
I understand that it was.
Yeah, we'll get clarification tomorrow.
Yeah. Great.
All right, well, let's leave it there. I mean, this is definitely, I want to be respectful of your time.
I thank you, Chair Stephen.
And,
I have to go raise some revenue upstairs.
oh, absolutely. Sorry, I was about to pun on that, but.
I know, but that increasing taxes.
I was gonna bring up some kind of high octane kind of comment based on lead and gasoline, but that's a little.
Oh, yeah. I still say, would you please fill it with unleaded regular? Oh, we don't have leaded gasoline anymore.
Oh, there's a few gas stations. No,
Oh, really?
No, they don't do unleaded. They just don't.
For my mom.
They don't do the ethanol. Some of the people who do.
Okay, all right.
Anyway, thank you very much and.
Pleasure. It was so nice to be with all of you.
Yes, I guess you've been in a silo. You're in
Yes.
your room, so.
Upstairs.
It's almost like being outside, except we can't see a thing.
You have more light in here than we do.
Nice.
Glad you think so. Not from my
Yes.
angle.
Okay, thank you very much, everybody.
All right, and what we have, from Legislative Council, we have Katie McLean just to walk us through this 2-page bill. And needless to say, folks, learning, we are not just housing, but general, and this bill originally came through Human Services, it was passed through Human Services based on some other federal laws. But just to give you an idea of what we would be working on above and beyond processes, understanding what the lead laws are and how they've evolved over the last 50 years or so. And that's not for today, but that's lead in paint is one of those products that I think I've seen public service announcements on for as long as I can remember about the dangers of lead paint and the attempts to try to make sure that public health thing is remediated in some way, and this clearly is part of that conversation. So Katie, welcome back.
Thank you. Katie McLean, Office of Legislative Counsel. It's the first time I'm in this committee.
Oh, well,
for
then
this.
let's go around the circle. We have some time considering it's only a 2-page bill.
Okay.
Representative Stevens from the Washington Chinle District.
Lamont, Morristown, Elmore, Worcester, Woodbury, and the northern part of Stowe.
Joe Parsons, Newbury, Topsom, and Groton.
Emily Krasnow, South Burlington.
Caleb Elder, Bristol, Lincoln, Moncton, Starksboro.
Dennis Labownie, Linden, Sutton, Newark, Sheffield, Wheelock.
Hi, I'm Elizabeth Burrows. I represent Heartland, West Windsor, and Windsor.
I'm Larry Labor. I represent Orleans, Essex, District 1.
And Robin Chestnut Tangerine, Rutland, Bennington District. Nice to meet you.
So with the exception of Representative Parsons and Howard, who's not here right this minute,
This is a new committee.
it's a whole new committee.
I know.
So welcome.
Thank you. So I know you'd like to get to the walkthrough. I have a few notes. I guess I thought it would be helpful to take a step back and tell you a little bit, a brief history. I'm not going to go back 50 years, but just to tell you what's happened in the legislature in the last 10 years. And I think that might give a little bit of context for where we are now. So historically, the lead paint program and the renovation, repair, painting, maintenance, RRPM, has been managed by the US EPA. And there's language in federal regulation that allows a state to apply to take over the program from the US EPA. And in order to be able to do that, the state has to meet certain criteria and has to make sure the program is provides the same safety mechanisms or enhanced safety mechanisms over what is required at the federal level. So in 2018, there was an act passed. I want to say it was 149. I have it in my notes, 149. And that was the first step in moving Vermont towards having the RRPM program in state versus operated and managed at the federal level. That was the step towards having Vermont have the administrative control over the RRPM program. So if you happen to take a look at that bill, you'll notice something unusual. If you scroll to the end, when you look at the effective section, we don't have an effective date on that section. And that is because in order for Vermont to administer its own program, it has to get approval from the US EPA. So instead of an effective date of, July 1, 2020 or 2018, it says this will take effect when the US EPA says, we've met the criteria and it has approved our program. So enacting the law was just the first step in that process. And then there are other steps in the process. Once the state applies, it's noticed on the Federal Register, there's opportunity for comment, et cetera. So the culmination of that process was that just this last October, the EPA approved Vermont's program. So even though this act was passed in 2018, the statutes technically only took effect this fall when the EPA approved the program. So that sort of gives you some framework about what the program is, how we got here.
And just quickly, under this process, I mean, it sounds strikingly familiar to daylight savings time. Like we can do a resolution or a bill that says we'll adopt whatever the federal government decides to adopt further down the line. But was there any warning? Was there any knowledge that that the feds were going to approve Vermont's application, or did it just come in the mail after 4 years? And
That's a better question for the health department. Did you, well, you'll hear from the health department. Okay. So that was the process. And I know you've been receiving a lot of mail about now this provision with regard to landlords and whether they should be treated more as what's called an RRPM firm, in which case they would need a license and they would have certain insurance requirements on them, as opposed to receiving a certificate or certification as childcare providers are treated, so they could do their own work under a certificate and not a licensure. And I feel like my testimony is sort of unsatisfying, as I'm not going to, answer what is appropriate. I think the question that you may want to be asking the health department tomorrow is how that will impact our, making that change will impact our authorization from EPA. Does there have to be a reapplication process? And I think the concern is, in Vermont statute, we have language. Where is the language? The department shall develop a program to administer and enforce lead-based paint lead-based paint activities and RRPM activities with regard to training and licensing standards, rules, and other requirements established by the commissioner, which are at least as protective of human health and the environment as applicable federal programs for persons engaged in lead-based paint activities and RRPM activities performed on target housing, child-occupied facilities, et cetera. So I think the question is, if we make that change as proposed in the bill, is this still as protective of human health and the environment as applicable federal programs? So I think that is the underlying question when you make your decision, and how, if it is, what does the application process look like, or the authorization process look like with the EPA? Does the EPA have to look like this again, or does it potentially undermine the existing approval that this state has received? So I think that is sort of the structural question you're looking at as you sort through this issue. So with that said, I will bring you to the actual language of the bill.
And before you do that, then, do you think that that's an answer? Where can that answer be gleaned from? Is that something we have to talk to the EPA about, or is that something the health department would be talking to the EPA about as the applying agency or what have you?
My experience of going through the last bill is that there is some conversation between the health department and EPA as the bill was moving. I don't know what the process would be like here. That's a better question for the health department. I do know, for example, we came back in 2019 and we had a bill that amended the 2018 bill because the EPA had some concerns that the language wasn't sufficient to meet their standards. So there was a second 2019 act that was passed to tighten up some of the language in order to meet this EPA authorization. So I don't know what the conversation looks like between the health department and the EPA.
And again, the authorization was that so that the state would enforce these EPA regulations with respect to lead paint, and but only under the federal rules, more or less.
The federal standards being sort of the floor.
Yeah.
Yeah.
Okay. All right.
So it's our own statute, but the standard is at least where the federal standard is.
We can make it stronger. No.
Thank you. Yes. Okay. Let's see if I can share this document. Okay, got it. Okay, here is the document itself. We have a legislative intent section because I don't think it's clear just looking at the language itself what exactly is being proposed. So I think the legislative intent helps clarify what's happening. It states that the intent of the General Assembly, it is the intent of the General Assembly that the owner of rental housing may perform RRPM as defined in 1751, that's the renovation, repair, painting, mitigation, on the owner's rental property under certificate instead of a license. And then in section 1752, we have this paragraph D. Right now, it says that the commissioner shall certify individuals engaged in RRPM activities for no compensation and who have successfully completed an accredited training program and met all other requirements as the commissioner may impose by rule. The proposal would say, as used in the subsection, individuals engaged in RRPM activities for no compensation includes the owner of rental housing who performs RRPM at the owner's rental property. And we have an effective date of July 1, 2023.
Do you know if the existing language, so this includes individuals engaged in RBPM for no compensation? Or adds to that list? Is that list currently limited to childcare providers, or are there other categories?
I believe so. I believe it's only limited to childcare providers. Let me confirm and get back to you.
Right, when we heard about the 3 pots,
Yeah.
basically, we're talking about, if I heard that correctly, those 3 pots had to be put into 2 different places, and one was going to be for the one not sure if it was supposed to or should have been or what have you, but what we're hearing is that the idea was that landlords who are not considered developers or I don't know what the right phrase is. Well, and I'm sorry, anybody who owns a rental and takes money for services is a professional of some sort. That's the definition of being a professional. I understand there's a difference here that we're talking about in terms of landlords of a certain size at the very least, that we'll have to clarify. But the intent, I think, or what we're hearing is that people who that these folks should have, as this is implying, that they should have been put into the pot with childcare centers where they just needed to be certificated and not charge the fees. That I believe would be the outcome of this.
That would be the outcome of this, yeah.
Okay. Yes.
Do you know, do they still make, could you still buy base lead paint?
I cannot answer that question. I'm sorry.
Yeah,
No.
yeah, okay, so now, let's say I'm a landlord and let's say I bought a place that was built 10 years ago. And if I can't get my hands on lead paint, then would I still need to be licensed?
This is for lead-based paint.
Just for lead-based paint?
Yeah, there's a whole series of regulations that have gone into effect. I mean, your house is your castle, so if you want to scrape lead paint off your house and suck up the dust and lower your IQ, you're more than welcome to under certain conditions. But if you're hiring a painter, they have to shroud, a professional painter technically has to shroud your house so the dust doesn't get into the neighborhood. And inside the house, there's different ways of treating lead paint, ranging from you just have to paint over it, without flaking it off. This is again an EPA rule an EPA regulation that is being put into it. But I know if it's only latex paint, I'm sorry, that's just a long way, I guess, of saying if it's only latex paint.
Okay. Well, no, I was just wondering, I'm a landlord, but if I wanted to, do a little bit of remodeling in my house, but it's not, prior to when the paint was banned, then I wouldn't need to have a license to do that.
Right, but if I wanted to turn
Yeah.
the upstairs of my house back into an apartment,
Yeah.
and rent it out, then I would have to.
Okay.
I wouldn't necessarily have to remediate from lead, But if I were going, I mean, I have to paint over at the very least,
Yeah.
and then
Right.
there's this certification. That's my understanding right now.
Thank you.
Representative Elder?
Well, I think if you own a house that's built before 1978, I think you have to do this anytime you are disturbing more than a square foot of interior room or a square foot of exterior surface. I don't think it matters. I don't know, like if they've done the full lead remediation that a lot of homes in Burlington have done, that doesn't eliminate the need to do this if they do subsequent work. Is that right?
I believe so, but I feel like that's a better question for the health
Yeah,
department.
I mean, my impression is that this is like, if the house is built before 1978, regardless of how much lead remediation has been done, this is an obligation that remains in perpetuity. I think that's the case.
Right, we'll clarify that.
And I mean, so it's not just about, you know, of course you can't get any, well, you can't get any lead-based paint. But anyhow, so I think it just kind of goes on and on, which kind of does underscore the burden on a landlord who, you know, we want people to be able to do, you know, a square foot of disturbance every now and then.
Right, and we have the oldest housing stock, so saying that your house was built before 1978 is not a weird thing.
It's kind of like saying you have a house.
Yeah.
All right, let's stop there, and thank you, Katie, for making time. Then we can grab you
Thank you.
to the committee or have you in the committee for a half hour, and we will take some further introductory testimony on this tomorrow with the health department and with we will be back here at 10:40